sentence for his convictions for armed robbery, leaving the scene of an accident, and fleeing and eluding. He went to trial only on count one robbery, and the trial focused on a single issue. Did Mr. Walters carry a firearm? The only disputed issue. In fact, in the opening statement, the defense counsel conceded, transcript page 453, that Mr. Walters committed the robbery, but did not do so with a firearm. On appeal, we have raised a number of evidentiary issues and are seeking preservation or certification of an issue pertaining to the PRR sentencing. We raise an improper golden rule argument by the prosecutor on count one, insufficient evidence of robbery, the firearm component in point two, prejudicial error in the admission of crash and fleeing evidence to which Mr. Walters had pled guilty before trial, and those crimes were not at issue. The verdict was contrary to the evidence, and the court used the wrong standard in ruling on the motion for new trial, and prejudicial comments by the prosecutor during argument. Let me move to the first issue, which is raised as an improper golden rule argument. And it is conceded that the prosecution in rebuttal argument twice imported to the jury to put themselves in the position of the victims of this robbery and consider what it's like to have a gun put into their faces. Transcript pages.
If I may, Mr. Cuny, and I know you've raised that in your brief, and when that occurred, defense counsel did object, as the transcript reflect, and the objection was sustained by the court, which again, the transcript reflect. And here's my concern though. Defense counsel did not move for a mistrial or ask for curative instruction. So help me out, and you know the case law that basically requires, in order for this issue to be preserved, that counsel needed to go forward to move for a mistrial or ask for curative instruction. So how do you respond to that concern?
Yes, Your Honor. 2 points. First, let me preface by making clear that this error, if preserved, is harmful under all circumstances. Here, there was a contemporaneous objection. The judge thought so much as to admonish the prosecution at sidebar. We asked the court to consider that in the motion for new trial, the defense raised the mistrial issue within the quantum of the entirety of the case. The Pedrov case, the 5th DCA case in 2000, makes clear that you can preserve a mistrial by timely raising it in a motion for new trial. We concede no mistrial or request for curative instruction was made. That was a deficiency.
And if I may, Mr. Gibbs, I looked at the Pedroza case. The Pedroza case dealt with, it's a Jimmy Rice commitment, but that was a civil type of case. And our case here, and I think also you've raised the issue of Murphy, and I looked at Murphy as well, but again, it deals with a civil context. So you're asking us to expand that from the civil context to the criminal context?
Yes, Your Honor. We've cited the Pedroza case, which does come in the context of the sentencing Jimmy Rice, as making clear that there is an opportunity to preserve a mistrial request if raised in a motion for new trial. Under these circumstances, this error was so plain and clear, and it so impacted the jury in this case, where the only issue was firearm versus gun or other weapon, that we believe it should rise to the level of fundamental error if the court determines that this error was not sufficiently preserved for appellate review. That does lead to the second issue that we've raised on the proof of firearm. And there is no doubt that the law requires affirmative proof of a firearm. Statutory definition 812.13, expelling a projectile by action of an explosive. There was testimony at this trial that the defendant, Mr. Walters, carried a gun. However, the clear testimony was that it was a BB gun. Several references, both in the 9/11 calls and at trial, was to the fact that it was a BB gun. There was also testimony about it looking like a Walmart plastic fake gun, but plainly the only gun description during the trial, the specific gun description was as a BB gun. And the law is very clear, as set out in the briefs. A BB gun does not constitute a firearm, and depending on the evidence and proof, it doesn't constitute a deadly weapon. That makes a sufficient difference with regard to whether this is a felony of the second degree, felony of the...
There was a teller who testified to that, but wasn't there another teller who basically, I'm looking at the transcript here, that this is one of the tellers, I can't remember her name right now, who testified that she was held at gunpoint, and she said that she was familiar with firearms, and that she was 100% certain that the gun was real. She felt it against, and there was testimony, she felt it hard against her back, or she felt against her back and it was hard. And then another employee testified that the robber tapped the gun on a metal coin locker, which sounded metal on metal. And the main reason I bring that out, because in the context of a motion for a JOA, you have to look at what's being presented. You're correct that there was one teller that said BB gun, but there's also other testimony regarding it being a real gun. How do you reconcile that?
First, Your Honor, that witness is Murphy Johns, a bank teller, Ms. Murphy Johns, who testified, I'm familiar with firearms, and that was a gun. There is no inconsistency in the testimony whatsoever. Put to the side that Ms. Murphy Johns never mentioned a gun of any type, a firearm of any type, in her deposition or in her, I think it's called the robbery report. The only mention in 911 and the robbery reports is a BB gun. Now note, Ms. Johns said, I'm familiar with firearms. I've got a hunting license. This was a gun, and it was real. Let's concede, for purposes of argument, that that evidence is enough to be taken by the jury as saying it was a gun. That does not establish the element of a firearm. A firearm is distinctly different from a gun. A firearm is, and I've given the definition. So even Ms. Johns, who's familiar with firearms, never said, oh, this was a firearm. Maybe that was a mistake, maybe not. She just testified it was a gun. Then the rest of the descriptions from Ms. Orena, a teller, and the 911 and the bank manager was transcript 898. It looked like a black BB gun. Transcript 900 to 904. It looked like a black BB gun, the kind that you would buy at Walmart. The robbery form, it looked like a BB gun. And most importantly, Ms. Orena said there were no bullets in the spindle. Second aspect, that it can't be a firearm without bullets, and she testified to that. So the most the state can argue on this case, and what the judge missed in ruling on the judgment of acquittal and later in the motion for new trial preserved on weight of the evidence, is to let the jury decide. When the only issue the jury could have decided as a matter of law was whether Mr. Walters carried a gun, not the charged firearm that would equate to a first degree punishable by life. The evidence is clear under Butler versus State. It's an objective test, not the victim's belief in what it was, an objective test. And the only evidence in this trial, no gun was found, no BB gun, no firearm was found. The only evidence in this trial is speculative as to firearm. And we've cited this court's case in Tribbett versus State that has remarkably similar evidence where witnesses testified about the weapon. And there was no testimony objectively that it was a firearm. We believe
I'm curious, Mr. Cooney, because you mentioned firearm. Wasn't the information use of deadly weapon also used deadly weapon? So not necessarily, I know you're focusing on firearm, but also deadly weapon. Does that change
Your Honor,
does that change?
Charge was firearm or a deadly weapon.
Correct. Does that change the
firearm
equation?
As a matter of course is a deadly weapon. Firearm was not established. So the test in Tribbett and CW versus State, which says, by the way, a BB gun is not a deadly weapon, is how was it used? Interestingly, no witness testified to being threatened with being shot. The gun, whatever it was shown. It was tapped. Directions were given by, frankly, a very polite robber who never threatened to use the weapon in any way that would convert to a deadly weapon. And that's the Santiago case.
But Mr. Cooney, isn't that being in dispute? I know you mentioned very polite, but there was also testimony from one of the tellers that he walked in very purposefully. He ordered her to go down. When she was down, her testimony was, I thought I was going to die. You don't think that also goes into the fact that fear of her life, really thought that she was going to die? Granted, he seemed to be, I know there's testimony that one of the tellers showed him the way out, but not as polite. I mean, if you look at the whole circumstances and the video, he knew what he was doing. He was all covered. And so the jury had an opportunity to observe all of that in the context of the case.
Yes, Your Honor. So I want to be very clear in my comment about being polite. Nobody suggested this trial that committing a robbery is polite under any circumstances. In terms of the conduct, in the Butler case, First District makes clear that the objective test says what the victims thought is not the proof of the deadly weapon or the firearm.
Rather, and that's true, Mr. Coon, but in that case, the facts of that case, neither of the employees actually saw a gun or any portion of one. The defendant just simply intimated that he had a gun. So that's a little different factually from what we have here.
No doubt. But the next question becomes, as the court asks, isn't it reasonable for the jury to determine that the victims were in fear of their life? Certainly that's something the jury is allowed to determine, but that does not satisfy the element of proof beyond a reasonable doubt of the deadly weapon. Rather, it is how objectively, first of all, what do you have, and how objectively the weapon is utilized. No testimony, none, about threats from the defendant. No testimony, none, about killing them. Yes, they were absolutely frightened for their lives. Frankly, that's why the prosecutor went over the line in saying, how would you feel if this gun was pointed at you? Precisely because there was no proof of firearm enough to get the offense risen to the level of a first-degree PBL. We asked the court to determine that the evidence is insufficient to support the proof of deadly weapon or firearm, and instead this court should reduce the offense level of robbery to robbery, not firearm, not deadly weapon. That does lead to the third issue in terms of how did the jury convict? And there was evidence of a classic car chase, police pursuit, and crash evidence that the state said, oh, this is for consciousness of guilt. That issue was removed from the jury's consideration by the defense concession at the opening that this case is solely about, was it a gun, a firearm, or something else, a BB gun? That was the closing argument. There was no consciousness of guilt running away. Mr. Walters had pled to the police pursuit and the crash evidence, yet this case became almost a whole day of this trial. Half a day, one day, day two, half a day, day three. The judge in preliminary rulings had said, okay, I'm not going to admit the video evidence of the crash, the chase and the crash, but the rest of it is usable. Fully preserved objection, fully preserved ruling by the trial court. And not only were the police allowed to testify about the chase, and the person who videotaped it, video not allowed, was allowed to testify, but the Donaldsons, the participants in the crash, were able to testify, and that became the feature of this case. Who wouldn't feel as a jury that this man, Mr. Walters, was a danger to society? Of course, he needs to be convicted. The testimony was immaterial.
But Mr. McKeon, and I appreciate the fact about your client pleading to that, and the court, as you said, did not allow that video to come in. But wasn't the state permitted to show consciousness of guilt and an opportunity to dispense the firearm that was used in the robbery? Because the whole point was, where is the gun? Where is the gun? And even heard with the prosecutor at the closing, I wish we had the gun, but they needed to show, where's the gun? Where's the gun? Well, that gave them the consciousness of guilt, and it was during that time that for that issue to be brought to the jury, that may have been an opportunity for him to dispose the firearm. Don't you think that's relevant in that context?
Your Honor, that's the misdirection that the prosecution attempted to demonstrate here. The consciousness of guilt. The defendant conceded he had a weapon. Obviously, no weapon was found. The consciousness of guilt, if it was throwing the weapon away, if that was the consciousness of guilt, as opposed to, frankly, what the prosecution argued, the consciousness of guilt of the robbery, throwing the weapon away, that still does not establish the consciousness of guilt of throwing a firearm or deadly weapon away. The prosecution collapsed this consciousness of guilt of the robbery into the specific, oh, this is to show that it's not our fault, we can't find the gun. Lack of proof, blaming it on the defendant. That could have been established had the judge ruled the way the defense had requested, simply by establishing when they arrested him, there was no gun to be found.
We are a little bit past 16, counsel. I want to let you know. A little bit past 16.
Yes, Your Honors. We rely on the remainder of the brief fully set forth to ask the court to vacate the conviction for robbery, remand the case for resentencing, and certify the PRR question. Thank you, Your Honors.
Thank you, counsel.
May it please the court, I'm Catherine Klein, Assistant Attorney.
Counsel, before you start,
Oh,
I wanted to do my mea culpa. I forgot to start counsel for the appellant's clock when he began. So if you find you're running out of time, you have a little bit of reserve thanks to my error. And I think I will look favorably upon your request to give you extra time since I was late to starting the clock.
Okay, thank you.
I bet give everybody the same amount of time.
Okay, may it please the court, Catherine Klein, the Attorney General's office in Tampa, representing the state in this case. The first issue is the golden rule issue, and this issue was not preserved. The trial counsel, although her objections were sustained, did not move for a mistrial or a curative instruction, and did not preserve this issue for the rule, for review. And this error does not amount to a fundamental error in this case. In fact, you could argue that although it walked the line, this might not have been an actual golden rule violation, because in the context, the arguments were not appeals to the juror's sympathy or improper reference to their victim's suffering. In context of this argument, the trial counsel was, and you can tell he's attempting to, they're talking about the possibility this is a BB gun, and that the proximity of this gun to the tellers in this case, could be considered a deadly weapon in the manner in which he was using it. Although the trial court did sustain golden rule objections. And the state maintains this is not fundamental error, because this was fundamental error is whether the error goes to the foundation of the case or goes to the merits of the cause of action, and whether the jury could have reached this verdict without it. And when you consider the other evidence in this case of the firearm and this bleeds into issue 2, this would not rise to the level of fundamental error.
And Ms. Klein, if I may, the jury also viewed the security footage that showed the defendant wielding the gun around, showed him fully clothed. So they've had that opportunity as well to observe the actual occurrence, in addition to having the witnesses testified as to what their observation. Am I correct?
Correct, Your Honor. There was a bank surveillance video with multiple views of the bank robbery, including a view of all the tellers, and then a view of the defendant or the appellant jumping the teller wall with what appears to be a firearm in his hand. And if you pause that video at I wrote it down here at 15:49:22, you can see the best view of the actual firearm that he's holding in his hand. So if we're going to the golden rule, and it also shows him using the weapon to direct the employees, holding it against their bodies, and then and then the conduct of throughout the robbery, he's holding this firearm. And we would say this does not amount to a fundamental error if it is indeed a golden rule, a violation. And if we bleed that into the JOA argument, the state was not required to show that this firearm was capable of expelling a projectile. We have to consider the testimony of the witnesses, and as we mentioned earlier, Ms. Murphy Jones, she testified that she was experienced with handling firearms, and that she'd had experience handling them with her, I believe it was her uncle, shooting fire. She was familiar with firearms. She said the robber held the gun directly in front of her at eye level, and that she was 100% certain that the gun she saw in his hand was a real gun. And the appellant held the gun to her back. The pressure was heavy and hard. And she further testified that she had always maintained it was a real gun. Ms. Urena is another witness. She's the one who thought that the gun looked like a BB gun or plastic or fake. But when asked to look at the investigator's gun, she also thought a real gun looked plastic and fake. She referred to guns as a Clint Eastwood type gun, and it seems like she thought a real gun was probably a revolver. And in this case, if you look at that video footage, this looks like an automatic that would have like a magazine. Vanessa Hussaby, she was another teller at the bank. She testified that she saw that she didn't see the appellant jump the counter, but she heard the motion, and all of a sudden he was right behind me with a gun at my back, and he said, "Get down, get down." I saw the barrel tip of it when he pushed us down. He used the barrel of the gun to push us down on the ground. I felt a metal object in my back. He tapped this gun on a metal cabinet. It was metal on metal. And she said it was not plastic. And this also goes to the threatening manner of this robbery. And again, the jurors could watch the entire robbery on video surveillance. So under Akins-B stated it was not fatal to the prosecution for the state not to introduce the weapon into evidence. Eyewitness testimony is sufficient. In other cases supporting this proposition are Thompson v. State, as cited by Brief, and O'Brien. And Butler, as cited by the defense, is distinguishable in that the testimony in that case, no one actually saw a gun or any part of a gun in that case, and they found the evidence to be insufficient. And I'd also say that given the evidence presented at trial, even if this was a BB gun, the jury could infer that it could cause a great bodily harm under the circumstances and therefore be a deadly weapon. As far as the issue 3, and that's the admission of evidence from flight of the scene of the robbery. The trial court did not abuse its discretion in admitting this evidence. The trial court left out the video of the police camera video of the chase going from the Arby's to the place where Mr. Walters was eventually apprehended, hiding behind the air conditioning unit. The state needs to prove the case of robbery. The defense does not dictate what the state's case is by conceding to the robbery. What we had here, we had to show, and as we know, it comes down to whether there's a firearm or a deadly weapon in this case. And this flight from the bank robbery does show a consciousness of guilt and the opportunity to dispense with the gun during that flight from the robbery, where he stopped a couple times and actually got out of a car and ran. And this was not a misdirection by the state. And if this court has no further questions, I'll rest on the other issues on my briefs. No. Well, thank you. I'd ask you to affirm his conviction and sentence.
Thank you, counsel. Counsel, you have 3 remaining.
In brief rebuttal, Your Honors, on the issue of the deadly weapon / firearm, it is quite plain in the cases cited in the briefs, including the state's brief, that the general phrasing gun does not equate to a firearm and does not equate to a deadly weapon. The CW case out of this court cited makes clear that a BB gun is a gun, but it is not a deadly weapon as a matter of law and fact.
But if I may, Mr. Cuny, because I know we said that in CW, but there's a recent case, I believe it's MDM, that were recently published in opinions saying that using a BB gun and implying it is a real gun is enough to get over a JOA on a deadly weapon status.
Yes, Your Honor, and that goes back to the objective evidence of the gun being wielded in a manner that appears to identify it as a real gun. Not a real gun as is used in this testimony repeatedly, but a real firearm. And the MG case, distinct from CW, makes clear that the content and the actions by the defendant to not just put people in fear of their life, but make it clear to them that they are going to be shot with this gun based on the circumstances. There is not sufficient evidence in this case, both for the JOA and the weighing test on the motion for new trial, which the brief makes clear the trial judge basically missed that weighing standard and deferred to the jury's verdict, is not sufficient as a matter of law and fact to rise to the level of a deadly weapon / firearm. We believe the court should do as it did in Tribbett, find that a robbery occurred, not a robbery with a firearm, not a robbery with a deadly weapon, and reduce the offense of conviction accordingly, which would require the vacation of the life sentence and a remand for further proceedings at sentencing. We preserve and raise all other issues presented and ask the court to vacate, reverse, and resentence, and to certify the PRR question as a matter of sufficient public importance. Thank you, Your Honors.
Thank you, counsel.
Thank you, Mr. Cuny. Thank you, Ms.
Good.
Klein. Well argued on
We
both
will
sides.
allow
Thank you.
To transfer electronically and all those atoms and stuff back to the point of origin. Be safe, and I look forward to seeing you all again.
Judge
And you, Your
Casanova,
Honor.
could we ask Attorney Klein to just people swap, but don't leave the webinar? Perfect, there we go.
You are
Excellent,
muted,
thank
counsel.
you.
Okay, thank you all. We'll call the second case.